All right, so over the past several weeks, we have spent a great deal of time talking about the powers of the government. We've looked at the structure of the Constitution, the separation of powers, federalism, judicial review, and the protections found in the Bill of Rights. And in many ways, we've been asking the same question over and over again. What can the government do? All right. Well, today we're going to be asking a different question. And instead of focusing on the government's authority, we're going to focus on yours, okay? How much control should you have over your own life? And at first, it probably sounds like a very simple question. Most of us would say that adults should be free to make their own personal decisions, especially when those decisions don't harm anyone else, right? But constitutional law has a way of taking a very simple question and revealing just how complicated they really are. All right. So imagine that your state legislature has passed a law tomorrow that requires every child to attend public school. Private schools would close, religious schools would close, homeschooling would no longer be allowed, and lawmakers explained that a single educational system would create better citizens and strengthen the country. Now, how many of you immediately thought, the government can't do that? All right. Now, let me ask you the harder question. Where does the Constitution actually say that? Because it's not at all where you think it should say it. Okay. It's not where you believe it outright says it. Where does it actually say parents have a constitutional right to decide how their children are educated? Because that answer is nowhere. All right. Now imagine another law, and this one prohibits married couples from purchasing birth control. Again, most people instinctively believe that the government shouldn't be making that decision. But where in the Constitution does it say that married people have that right? It doesn't. Okay. What about the right to marry the person you love, or the right to decide whether to have children, or the right to make private decisions in your own home without government interference? Again, you're not going to find those words written anywhere in the Constitution. So, how did those become constitutional rights? That's the reason that we're here today. That's what we're talking about. Okay. Everything we're going to study in this lecture grows out of a single word found in the 14th Amendment. And it's not a long phrase, it's not an entire paragraph. It is literally one single word, and it's liberty. Okay? The Constitution tells us that the government may not deprive any person of liberty without due process of law. But what it never tells us is what liberty actually means. Okay? Does liberty simply mean that the government can't throw you in jail without a fair trial? Or does liberty also protect, things like deeply personal decisions that define who we are as individuals? Does it protect our families, our marriages, our medical decisions, our identities, our relationships? All right. So, for more than a century, the Supreme Court has wrestled with those very questions. All right. Sometimes the justices agree, sometimes they disagree, and sometimes that disagreement is so strong that they wrote opinions criticizing one another. All right. Sometimes the court expands the meaning of liberty, sometimes it pulls it back. In a few cases, the court later admitted that it had gotten the Constitution wrong the first time. And by the end of this lecture, you're going to see that today's cases are not isolated decisions. They are chapters in one continuing story. Each is building on the one before it, and each is asking that same fundamental question. Where does government authority end, and where does individual liberty begin? Now, before we begin examining cases, I do want to spend just a few minutes talking about how I hope you'll approach today's material, because this lecture is different from many of the constitutional topics that we've studied so far. All right. So in earlier modules, we often dealt with provisions of the Constitution that are fairly straightforward to locate. All right. If we wanted to talk about freedom of speech, we look to the First Amendment. If we wanted to discuss unreasonable searches and seizures, we look to the Fourth Amendment. The text itself gave us a place to begin, but today's topic is very different. All right, so one of the things that you'll notice is that many of the rights that we're going to discuss aren't actually written anywhere in the Constitution. And that fact alone has generated some of the most passionate disagreements in constitutional law. Okay, There are people, and I'm talking including judges, lawyers, professors, Supreme Court justices, who all believe that courts should never recognize a constitutional right unless the text clearly identifies it. All right. But others argue that the Constitution was intentionally written using very broad language because the framers understood that they couldn't possibly anticipate every question that future generations would face. Okay, so as we work through today's cases, I don't want you to focus immediately on whether or not you agree with the outcome. And let me tell you, that can be extremely tempting, especially when you have many of those decisions that involve, issues that people feel very strongly about. Instead, I want you to train yourself to think like someone who's working in the legal profession. All right. Your job is simply to understand how the court reached its conclusion. All right. What constitutional language did the justices rely on? What historical events influenced the case? How did earlier decisions shape the court's reasoning? What arguments did the dissenting justices make? And really, perhaps the most importantly, if a case had never existed, what would the next case have looked like? you know? And I think you'll discover that constitutional law isn't really a collection of isolated decisions. It's more like a conversation that has continued for generations. Okay, so one court asks a question, a later court answers it differently, and sometimes the courts refine an earlier idea. Sometimes it rejects it altogether, but every opinion becomes part of this ongoing dialogue that stretches across decades. All right, so you'll also notice something else as we kind of move through this, and that's that the word privacy. It appears in today's lecture title, but privacy is only a part of what we're studying. It's the broader concept of autonomy. All right, and autonomy simply means self-government. So in other words, it's the ability to make decisions about your own life without someone else making those decisions for you. Okay, so think about how many choices you make every single day without giving them much thought. All right, you decide what to wear, you decide what to eat, you decide who your friends are, you decide where you'll work, right? Some of those decisions are relatively insignificant. Others are going to shape the entire course of your life. So constitutional law is going to ask an important question about those decisions. Are those, choices, are they so personal that it's so fundamental to human dignity that the government should generally just stay out of them? All right, and that question lies at the center of every single case that we're going to study today. And by the end of the lecture, I hope that you'll understand that not only what substantive due process is, but why reasonable people, including Supreme Court justices, have disagreed so passionately about it for more than a century. All right, you're going to begin to see how today's lecture connects directly to the next module. The rights that we're about to study, they have laid the constitutional foundation for cases involving abortion, end of life decisions, and so many others that continue to divide the country today. All right, so as we begin, I want you to keep one question in the back of your mind, and it's a question that sounds very simple, but you'll discover it's anything but. And again, it's when the Constitution promises liberty, what exactly is it promising us? Now, before we can appreciate what makes substantive due process unique, we need to revisit a concept that we've already kind of encountered earlier in the semester. Sometimes students will confuse procedural due process and substantive due process because they share the same constitutional language, but they're two completely different questions that they answer, okay? So imagine that the state accuses you of professional misconduct and they want to revoke your, a law license or a medical license or nursing license, okay? Before it can do that, certain things have to happen. You have to have been told what you're being accused of doing. You have to receive notice of a hearing. You have to be given an opportunity to present evidence, to challenge witnesses, to explain yourself, give your side of the story, right? The person that's deciding your case should be neutral and impartial. And those requirements exist because our legal system recognizes that fairness matters. That is procedural due process. Okay? Procedural due process asks whether the government has followed fair procedures before taking away someone's life, liberty, or property. Okay, so it doesn't necessarily ask like whether the government's decision was correct. It just asks if the process itself was fair. All right, so think about a sporting event. Even if your favorite team loses, you're generally willing to accept the outcome if the officials applied the rules fairly to everyone, right? But if the referees ignored very obvious penalties, or they changed the rules like halfway through the game, or they refused to let one team present its case, then most people would probably say the process itself was grossly unfair, regardless of the final score. Okay? Procedural due process serves that same purpose in constitutional law. It seeks fairness. All right? Now, substantive due process begins somewhere entirely different. All right, so instead of asking whether the government followed proper procedures, substantive due process asks whether government should be allowed to exercise that power in the first place. So imagine that every procedural safeguard was followed perfectly. All right, you received notice, you have an attorney, you called witnesses, you were given a fair hearing, you have an impartial judge. Now imagine that at the end of this perfectly fair hearing, the government announces that you can never marry because it disapproves of the person or it disapproves of the person that you've chosen. Okay, so would the fairness of the hearing make that decision constitutional? And most of us would say very instinctively, no. The problem isn't the procedure. The problem is that the government has crossed the constitutional line by interfering with something that we believe should belong to the individual rather than to the state. All right, and that's the central idea behind substantive due process. It recognizes that some liberties are so fundamental that the government cannot simply regulate them whenever it chooses. So even if procedural protections have been observed, the Constitution may still prohibit the government from interfering with certain aspects of our lives. Okay, so as we move through today's lecture, you're going to notice that nearly every case asks some version of the same question. Is this a decision that the government should be making? Or is this a decision that belongs to the individual? And that question alone has shaped more than a century of constitutional law. And by the end of today's lecture, I hope that you'll understand why it remains one of the most debated issues even before the Supreme Court today. So now that we've distinguished procedural due process from substantive due process, let's spend a little bit of time developing this doctrine because it truly sits at the center of everything that we're going to discuss, through the course of this lecture. The phrase substantive due process can sound very intimidating the first time you hear it. So law students will often spend weeks trying to wrap their heads around it because at first glance, it almost sounds like a contradiction. Okay? I mean, after all, the due process clause appears to be talking about procedures. So how did it become the source of substantive rights? And the answer lies in the Supreme Court's interpretation of the word liberty. So when the 14th Amendment was ratified in 1868, it declared that no state could deprive anyone of life, liberty, or property without due process of law. Okay? And everyone agreed that the government couldn't simply throw someone in prison without a fair trial. That part, not controversial at all. All right? The controversy began when people started asking a much deeper question. What if the government follows every proper procedure, but the law itself invades a freedom that should belong to the individual? All right. What if the government isn't acting unfairly in how it applies the law, but instead is acting improperly by passing that law in the first place? Okay, so imagine your city council passes an ordinance that requires, every resident to obtain government approval before naming their newborn. Absurd, right? This ordinance, it creates a review board that's going to meet every single month. Parents, they'll get notice. They can appear before the board with an attorney, without an attorney, doesn't matter. They can appeal an unfavorable decision to a judge. Every imaginable procedural protection exists. Would that satisfy the Constitution? And the answer is probably not. But why is the question, okay? Because most people would argue, hey, me choosing my child's name, that is a deeply personal decision that belongs to me, the parent, not the government. All right. So the problem isn't the fairness of the hearing. The problem is that the government has inserted itself into an area of life, actually, an area of private life, where it has no legitimate business. And that's the heart of substantive due process. So the doctrine recognizes that some decisions are so closely connected to individual dignity and personal liberty that the government must have an extraordinarily, compelling reason before actually interfering with them. All right. But notice something important. Okay. The Supreme Court didn't wake up one morning and publish a list of these protected liberties. There's no official catalog of substantive due process rights. Instead, this doctrine has developed gradually, one case at a time. And every generation of justices inherited questions that previous generations had left unanswered. So each case became another opportunity to decide whether a particular, liberty interest deserved constitutional protection. So as you'll see as we're going through the lecture, the court has moved, I would say rather carefully. It didn't just begin by addressing controversial questions about marriage or sexuality or anything like that. Instead, it started with something far more familiar, which was parents and children. And that wasn't an accident. If you ask most people whether parents should generally be allowed to decide how their own children are raised, you will find very broad agreement. Okay? The court began with issues where liberty seemed almost intuitive. From there, it slowly expanded the doctrine into other areas of private life. Okay? So, one of the important lessons that you're going to learn today is that constitutional law often develops incrementally. So rather than making dramatic leaps, the court usually takes small steps, and each decision builds on principles recognized in earlier cases. So by the time, say, we reach Lawrence versus Texas and Obergefell versus Hodges, you'll see that those decisions did not appear out of thin air. They were built upon decades of earlier cases that gradually expanded the court's understanding of liberty. So when people argue about substantive due process today, they rarely are arguing about just one case. They're usually debating an entire constitutional philosophy that has evolved for more than 100 years. Now, everything that we've discussed so far ultimately comes back to one sentence in the 14th Amendment. And it's kind of remarkable to think that one sentence containing just a handful of words has generated some of the most significant constitutional decisions in American history. The amendment tells us that no state shall deprive any person, note that it says any person, does not say citizens or people born here, anything like that. It says any person of life, liberty, or property without due process of law. Life, liberty, property. Those are three concepts that sound so straightforward until you try to define them. Now, most of us have a fairly good understanding of what life means, and property can usually, be identified without a whole lot of disagreement. But liberty is another matter entirely, and that's because the Constitution never actually defines it. So there isn't a section that says, for the purposes of this document, liberty includes the following, ... Instead, the framers and the authors of the Reconstruction Amendments left the word deliberately broad. So whether that was intentional or just simply unavoidable, it still left future generations with a very enormous responsibility. All right, so think about the world in 1868 when the 14th Amendment was ratified. All right. You have no automobiles, no planes, no smartphones, no social media, no genetic testing, no artificial intelligence. Could the people who drafted the amendment have anticipated questions about digital privacy? Or how about reproductive technology? Or same sex marriage? Or even encrypted communications? Absolutely not. Okay. They couldn't write the rules for every situation for the future and what it might bring. And instead, they wrote principles. Okay. So the challenge for the Supreme Court has always been in determining how those principles apply to circumstances that the framers never imagined. So some justices have argued that liberty should be interpreted according to the public understanding of 1868. So if a claimed right would not have been recognized at that time, then they believe that the court should hesitate before declaring it constitutional. Others argue that liberty is an enduring principle. So rather than this like frozen historical concept, right? And in their view, the Constitution protects the fundamental aspects of human freedom, even when society changes and presents questions that the 19th century has never confronted. Okay? So you're going to see that the debate surfaces repeatedly throughout today's lecture. Sometimes the disagreement between the justices has less to do with the facts of the actual case and more with these competing philosophies of constitutional interpretation. Now, as future legal professionals, it is very important that you recognize this distinction. All right? Two judges may look at the same exact constitutional language and they may, study the same exact historical record, and they may even reach opposite conclusions, but it's not because one is ignoring the law, but it's because they're beginning with different assumptions about how the Constitution should be interpreted. All right. And neither approach makes constitutional law easy. In fact, I would say that it often makes it a lot more difficult. But it does also explain why Supreme Court decisions sometimes change over time, because the Constitution itself may remain the same, but the people who are interpreting it do not. Okay, so as new justices join the court, you have new historical research that emerges, and society evolves, and constitutional doctrine is going to evolve as well. All right, and that reality brings us to the first chapter in our story. So, to understand where the modern doctrine of substantive due process begins, we have to go back. We have to go back to America immediately following the First World War. This is when fear and patriotism and suspicion of immigrants combined to produce a law that many people believed was perfectly reasonable. All right. One teacher disagreed, and his name was Robert Meyer. And his decision to teach a child the German language would become one of the most important constitutional cases of the 20th century. Now, before we jump into Meyer, I need to give you a little more information. As we continue building our understanding of substantive due process, we need to answer a question that isn't addressed directly by the Constitution, but has become one of the most important questions in constitutional law. And that is, if liberty is protected by the 14th Amendment, does that mean that every liberty receives the same level of constitutional protection? And the answer is no. Okay. And understanding why is essential to understanding every single case that we're going to discuss for the rest of the course. All right. So think about the choices that you've made just since waking up this morning. All right. You probably decided again what to wear. What did you eat for breakfast? Did you stop for coffee or did you go straight to work? Did you take a special route to campus or did you take your regular one? What music or podcast did you listen to on the drive? Those are all choices, and in a very general sense, they're all exercises of personal freedom. But if the government decided tomorrow that every state employee had to wear blue shirts on Mondays, or that restaurants could no longer serve soft drinks larger than 16 ounces, then most courts would not treat those regulations as attacks on fundamental constitutional rights. Now, you might disagree with that policy. You might think that this is a very terrible law. but it doesn't automatically make it unconstitutional. Okay, so let's compare those examples to something much more significant. So suppose the government passed a law saying that parents no longer had the authority to decide where their children would be educated. Let's go back to that school conversation. Or imagine a law that prohibited, certain people from marrying because lawmakers disapproved of the relationship. What if the government decided that some citizens should not be allowed to have children because officials believe they would make poor parents? Those examples feel fundamentally different. At least they should. Um, and the reason they feel different, or the reason they should feel different, is that they involve decisions that define who we are. They shape our families, our identities, and the courses of our lives. Okay? They're reaching into areas that most people instinctively believe belongs to the individual rather than the government. Okay? So, over the past century, the Supreme Court has recognized that certain liberties occupy a special place within our constitutional system. So, those liberties are often referred to as your fundamental rights. They are considered so essential to individual freedom, and human dignity that the government cannot interfere with them simply because lawmakers think it would be doing good public policy. Okay? And it's important to recognize that the Constitution never gives us a master list of these fundamental rights. Again, the framers didn't include an appendix identifying every liberty that future generations should enjoy. And instead, the Supreme Court identified those rights gradually through individual cases. And one case recognized the importance of parents direct, being able to direct the upbringing of their children. Another one recognized procreation as one of humanity's basic civil rights. You have later cases that recognize contraception, intimate relationships, marriage. So this gradual development explains why today's lecture is so important. Again, none of these cases stand alone. All right? They're building upon principles established in the cases that came before it. And if you try to study them individually, they can seem completely unrelated. But when you step back and you look at them together, you do begin to see a pattern. The court wasn't creating entirely new rights like every few decades. It was slowly answering the same question over and over and over again. And that is, what does liberty really protect? Okay. And that question has never been easy to answer. And reasonable people, including Supreme Court justices, continue to disagree about it today. All right. Some people believe that courts should recognize only rights, again, that are explicitly listed in the Constitution or those that are deeply rooted in American history. Others believe liberty is a broader constitutional principle that has to be capable of protecting important aspects of human life as society evolves. And the debate will become more apparent as we move through because, again, every decision that you're about to study reflects one side of that ongoing constitutional conversation. Now, once the Supreme Court determines that a particular liberty is fundamental, the next question becomes whether or not the government has a sufficient reason to interfere with it. This is where we encounter one of the most important concepts in constitutional law, which is strict scrutiny. If you have never heard that phrase before, don't let it intimidate you or anything. The idea itself is actually fairly straightforward. Imagine that you're hiring somebody to babysit your children. You probably aren't going to make a decision after a 2-minute conversation. You're likely going to ask questions, check references, run a background check. But why? And that's because the stakes are incredibly high, right? This is somebody that you're trusting with the people who matter the most to you. So naturally, you're going to examine that decision very, very carefully. All right. Now compare that to like buying a bottle of water at a convenience store. All right. Most of us don't spend, 20 minutes researching different brands before making that purchase. that decision is relatively minor. And so the amount of scrutiny that we give it is lower. All right. Courts approach constitutional questions in the same way. So when the government regulates matters that don't involve fundamental constitutional rights, courts generally give lawmakers considerable flexibility. So legislatures are elected to make policy decisions, and judges usually defer to those decisions as long as they have some reasonable basis. All right, but everything changes when the government attempts to interfere with a fundamental right. And at that point, courts become much more skeptical. So instead of assuming that the government acted appropriately, the court begins asking difficult questions. What exactly is the government's objective? Is that objective important enough to justify limiting an individual's constitutional liberty? Could the government accomplish the same goal in the same way that interferes less with personal freedom? All right. So to satisfy strict scrutiny, the government has to prove that it has a compelling governmental interest. That's legal terminology that you're going to hear repeatedly throughout constitutional law. So let's take a moment to really understand it. A compelling interest is not something that the government would like to accomplish. It's not something that's about convenience or efficiency. It refers to an objective of the highest constitutional importance. All right. For example, protecting the country from a genuine national security threat could qualify as a compelling interest. Preventing the spread of a highly contagious and highly, deadly disease could also qualify. Protecting children from immediate physical harm, another example. These are interests that society generally recognizes as extraordinarily important. Okay, so even if the government demonstrates a compelling interest, the analysis doesn't end there. Okay, the government has to also prove that the law is narrowly tailored, meaning it restricts constitutional liberty no more than necessary to accomplish the objective. So think of it this way. If you needed to remove a single weed from your garden, you're not going to bulldoze the entire yard, right? You're going to, and let's just face it, that would eliminate the weed, but it would also destroy everything else in the process. Well, constitutional law expects the government to solve problems with precision rather than overreaction. Okay, so if there's another way to accomplish the same objective while placing fewer restrictions on individual liberty, then the Constitution generally requires the government to choose the less restrictive approach. All right, and you'll often hear lawyers, say things like, strict scrutiny is strict in theory and fatal in fact. That phrase reflects the reality that many laws that have been reviewed under this standard will ultimately fail because the government cannot satisfy both parts of the test. So while strict scrutiny is not impossible to survive, it is intentionally difficult to survive. So the Constitution places a heavy burden on the government whenever it seeks to interfere with liberties that the Supreme Court has recognized as fundamental. So as we start beginning to examine our first cases, just kind of keep this concept in the back of your mind. The real battle is often not over whether or not the government has a compelling reason to act. Instead, the first and foremost important question is whether the liberty at issue is fundamental. And once the court answers that question, the level of constitutional protection is, and the outcome of the case can change dramatically. Now, one of the most important things that you can do when studying constitutional law is to remember that the Supreme Court cases don't happen in a vacuum. Every case reflects the society in which it arose. You're talking about the fears, the values, the politics, the cultural tensions, of a particular moment in history, and these will often become the backdrop against which constitutional questions get asked. All right. And if we ignore the historical context, we do risk misunderstanding why a case mattered in the first place. All right, so to understand Meyer versus Nebraska, we have to travel back to the years immediately following World War I. The war had just ended in 1918, but you have this emotional impact that lingered for a long time after. You have more than 4 million Americans who served in the military. You have families who lost loved ones. You have communities who celebrated victory, but they also carried deep scars from years of conflict. So patriotism reached extraordinary levels. And with that patriotism came suspicion. So the enemy during World War I had been Germany, right? And before the war, German culture was woven into everyday life throughout much of the United States, particularly the Midwest. You have millions of Americans who were of German descent. You have churches that conducted services in German. You have newspapers that were published in German. Families spoke German at home, and many schools taught students in both English and German. And none of that seemed unusual before the war. All right. Now, after the war, attitudes changed dramatically. All right. Speaking German no longer represented family heritage to many Americans. And instead, it became associated with the nation that had just fought against the United States. So, across the country, communities began distancing themselves from anything that was perceived as German. So, German language newspapers, they disappeared. Musical performance, having, music from German composers, canceled. You know, you have towns that changed their names of streets and businesses and things like that that sounded too German. At the same time, a movement known as Americanization was gaining momentum. And the basic idea was that the immigrants and their children should adopt American customs, meaning they should speak English and they should fully embrace, American civic values as quickly as possible. Many people genuinely believed that they were strengthening the country by encouraging this national unity. However, it often allowed fear and prejudice to influence public policy. All right, so Nebraska became one of the several states to pass laws reflecting this movement. And one of those laws prohibited schools from teaching modern foreign languages to children who had not yet reached eighth grade. Okay, so supporters argued that young children should first become proficient in English before learning another language. And they believed that this would create better citizens and promote, national unity. And on its face, the law appeared to concern education, but underneath that educational policy lay a much larger constitutional question. Who should decide how children are educated? Should that decision belong primarily to parents and teachers, or does the state have an authority to make those decisions for everyone? So that question eventually reached the Supreme Court because of one teacher who continued doing what he had always done, which was teaching children to read in German. And I totally realized that I kind of skipped ahead. We're going to talk about Pierce versus Society of the Sisters as well, but sit tight with me. Now, the teacher at the center of this case was Robert Meyer. Told you I'd come back to him. And he was an instructor at a private Lutheran school in Nebraska. And like many religious schools at the time, his school offered instruction in both English and German. And Meyer wasn't teaching political ideology. He wasn't encouraging disloyalty to the United States. He was simply helping students to learn another language. And on the day that changed constitutional history, he was reading a Bible story in German to a 10-year-old student. Someone observed the lesson and they reported him to local authorities. So, because Nebraska had recently enacted its foreign language law, Meyer was charged with violating the statute and he was convicted, fined, $25, and found guilty of committing a crime simply for teaching a language that millions of Americans had spoken for generations. So, rather than accepting the conviction, Meyer challenged the law itself and he argued that Nebraska had exceeded its constitutional authority and that the statute violated the liberty that was protected by the 14th Amendment. So the question before the Supreme Court was straightforward and profound. Okay? Did the Constitution allow a state to prohibit teachers from instructing young children in a foreign language? And writing for the majority was Justice James McReynolds, and he concluded that it did not. The court acknowledged that the state possesses broad authority to regulate education. States can establish curricula, they can require school attendance, they can certify teachers, and they can set these educational standards. But nothing in the Constitution prevents states from exercising those powers. All right, but the court explained that Nebraska had gone so much further than just regulating education because the law now interfered with the liberty of teachers to pursue their profession. The liberty of the parents to direct the education of their children, and then even the liberty of the students to get this knowledge. All right, so Justice McReynolds, he gave a remarkably broad description of liberty. He explained that liberty includes much more than freedom from physical restraint, rather. So it embraces the right to acquire useful knowledge, to establish a home, to bring up children, and to enjoy many of the ordinary privileges that are recognized by free people. That language was groundbreaking. Okay, so remember where we started this lecture. We asked whether liberty meant only freedoms from imprisonment or whether it protected something more. And in Meyer, the Supreme Court answered that question for the first time in a meaningful way. Liberty, the court said, includes important aspects of family life and education, and the government cannot simply override those decisions because it believes its policy is better. All right? And it is important to understand also what the court did not say. So the justices did not declare, education immune from regulation. Nebraska still could require children to attend school. It could still establish those educational standards, and it could still, make sure that their teachers are qualified. But what it could not do was unnecessarily interfere with decisions that were traditionally made by parents and educators without sufficiently strong constitutional justification. Okay, so looking back, Meyer may not seem like a case about privacy at all. No one's talking about like marriage or contraception or like intimate relationships, but it is the case that planted the first seed of an idea that would continue to grow for decades. And that is that some personal decisions belong to the individuals and families rather than the government. Now, only 2 years after deciding Pierce, the Supreme Court faced another case involving education. And at first glance, Pierce versus the Society of Sisters appears, kind of remarkably similar. But the constitutional principle that it established would become even more influential. Okay? So this story begins in Oregon during the early 1920s. And like many states during that period, Oregon experienced growing social and political movements that promoted assimilation and viewed public education as an important tool for shaping future citizens. Okay, so some organizations argued that every child should receive the same education in public schools because they believed that it would strengthen democracy and create greater national unity. So in 1922, Oregon voters approved the Compulsory Education Act. And that was a law that required nearly every child between the ages of 8 and 16 to attend public school. So if the law took effect, then most private schools, including those religious schools, would effectively disappear because families would no longer have the legal option of sending their children there. All right. So supporters believed that the law promoted equality by ensuring that every child received the same education. All right. Critics, they viewed it very differently. They argued that the government had crossed a line, not just, actually, let me back up, that they had crossed a very important constitutional boundary by attempting to eliminate parental choice altogether. Okay. So, two private schools challenged the law before it ever became effective. And one of those schools was operated by the Society of Sisters. This was a Catholic religious organization that was devoted to educating children. So the schools argued that the law interfered with the liberty of parents to choose the educational environment that they believed was best for their children. All right. Once again, Supreme Court, they agreed. They're on their side. Justice McReynolds, again, wrote for a unanimous court, and he built upon those principles that were announced in Meyer. Okay. And the court recognized that while the state has authority to require education and to regulate schools, that authority has limits. All right. So governments can establish reasonable educational standards, but it cannot standardize children by forcing every family into the same educational system. So the opinion contains one of the most enduring sentences in constitutional law, and that is that the child is not the mere creature of the state. All right? Those few words have been quoted in countless judicial opinions over the past century because they capture a fundamental constitutional principle. So parents, not government officials, bear the primary responsibility for directing the upbringing and the education of their children. Again, the state plays an important role, but it doesn't replace the family. So when we place Meyer and Pierce side by side, we see a pattern that begins to emerge. In Meyer, the court protected the ability of the parents and the teachers to decide what children would learn. In Pierce, it protected the ability of the parents to decide where children would learn. All right. Both decisions recognize that the government authority has constitutional limits when it enters the family sphere. Okay. So at this point, the Supreme Court, it still had not used the language of privacy. It hadn't recognized a general right of personal autonomy, but the foundation was quietly being built. All right. The court had begun recognizing that liberty includes more than freedom from imprisonment. It also includes the freedom of families to make some of life's most important decisions without unnecessary government interference. So, that understanding of liberty would soon be tested in a far more um, disturbing context when the government claimed the authority to decide not where people could educate their children, but whether certain people should be allowed to have children at all. So, the next case in our story requires us to examine one of the darkest chapters in American legal history. It is also one of the reasons why I believe it is so important to study constitutional law honestly. The Supreme Court has produced opinions that expanded freedom and protected individual rights, but has also produced decisions that have been judged very harshly, and rightfully so, by history. Um, if we're going to understand how constitutional law develops, we have to be willing to look at both. Okay. So during the late 19th century, early 20th century, you have a movement known as eugenics that gained popularity throughout the United States and much of Europe. The word eugenics comes from the Greek language and roughly translates to good birth. All right, so its supporters believed that society could be improved by encouraging people with desirable characteristics to have children while preventing those they considered undesirable from reproducing. All right, so today that idea sounds both morally and scientifically indefensible, but at the time it was embraced by many respected members of society. You have physicians that promoted it. You have scientists that published, research supporting it. Universities taught it. Politicians, they campaigned on it. You have legislatures that passed laws on it. And perhaps the most troubling of all is you have courts that were upholding those laws. All right. So the people targeted by these policies were not just violent criminals. They included individuals with intellectual disabilities, people suffering from mental illness, those living in poverty, individuals with epilepsy, and a whole lot of others that society just viewed as undesirable. All right, so the underlying assumption was that these traits were hereditary and that preventing certain people from having children would somehow improve future generations. All right, so that belief eventually produced laws authorizing forced sterilization. So, unlike temporary contraception, sterilization is intended to permanently prevent a person from having biological children. So thousands of Americans, they underwent the sterilization without their consent because the government officials concluded that they were unfit to become parents. So take a moment to really kind of appreciate the magnitude of that governmental power, because that wasn't simply regulating behavior. That wasn't imposing a fine or even a prison sentence. This was the government. They were making a permanent decision about whether or not a human being would ever have the opportunity to create a family. All right. And as difficult as it may be to imagine today, that was the legal landscape that was confronting the Supreme Court in the early 1940s. So the case that was before the court involved a man named Jack Skinner, and he had been convicted of, several times for theft related offenses. So Oklahoma had enacted a law known as the Habitual Criminal Sterilization Act. So, under that statute, individuals convicted 3 or more times of certain crimes could be involuntarily sterilized. Now, at first glance, someone might assume that the law applied equally to all repeat offenders, but it didn't. Okay? A person convicted multiple times of crimes like robbery or theft could be sterilized. But someone who repeatedly was convicted of embezzlement, which is a crime involving dishonesty and financial fraud, could not. So the law drew distinctions that seemed arbitrary, and it raised immediate concerns about the fairness and equal treatment. So Skinner challenged the statute before the Supreme Court, arguing that Oklahoma had violated the Constitution by selectively targeting certain individuals for permanent sterilization, and the court ultimately agreed. Okay? So Justice William O. Douglas wrote the opinion, and while the decision technically rested on the Equal Protection Clause, the language that he used would become enormously influential in the development of substantive due process. So Douglas described marriage and procreation as one of the basic civil rights of man. Okay? He recognized that the ability to have children is fundamental to the existence and the survival of humanity itself. So, because sterilization permanently deprives an individual of that ability, the court concluded that laws authorizing such a profound intrusion had to be examined with extraordinary care. So the significance of Skinner extends well beyond, the specific statute that the court struck down. This is for the first time the Supreme Court openly recognized procreation as a fundamental constitutional interest. So the government was no longer being asked whether it had followed proper procedures. Instead, the court questioned whether the government should possess this power at all. So the case, it also serves as an important reminder that constitutional rights do often emerge in response to governmental abuse. And history demonstrates that when the governments acquire the authority to decide who deserves to have children and who does not, the power is almost always exercised unfairly. And the Constitution exists in part to prevent those abuses from becoming permanent features of our society. I did get ahead a little bit, but I do want to pause for a minute because I do want to bring your attention to another case. And it's not a part of like any kind of assigned reading or anything, but it really is impossible to ignore when talking about Skinner. And that is the case of Buck versus Bell. And it was decided by the Supreme Court in 1927. Now, many constitutional scholars consider Buck versus Bell as one of the worst decisions that the Supreme Court has ever made. All right, and they've made some bonehead mistakes, but this one is pretty bad. So the case involved a young woman named Carrie Buck, who had been committed to the Virginia State Colony for epileptics and feeble-minded. So the state officials claimed that Carrie, her mother, and her infant daughter all suffered from intellectual disabilities. So, based on those allegations, Virginia sought permission to sterilize Carrie under its newly enacted eugenics law. So, when the case reached the Supreme Court, the justices upheld the statute. All right. So, Justice Oliver Wendell Holmes, he wrote the majority opinion, and he is looked at by many as being one of the most respected legal minds in history. But near the end of that opinion appears one of the most infamous sentences ever written by a Supreme Court justice. And he said, and I quote, 3 generations of imbeciles are enough. All right. History has not been kind to that statement, and rightfully so. In Carrie's case, you have subsequent research that suggested that she actually was not intellectually disabled at all. She had become pregnant after being sexually assaulted by a relative of her foster family. And rather than protecting her, the legal system labeled her defective, and they authorized the permanent loss of her reproductive rights. So the consequences of Buck versus Bell were devastating. Following that decision, you have states that across the country that were continuing to sterilize thousands of people, many of whom had committed no crimes whatsoever. Some who were just poor, some who had disabilities, and others who were just considered socially undesirable. Okay? So, one of the reasons that Skinner became so important is that it dramatically weakened the constitutional foundation supporting those sterilization programs. And although the Supreme Court never explicitly overruled Buck versus Bell, Skinner still recognized procreation as one of the most basic civil rights that were protected by the Constitution. And that made recognition, it made it increasingly difficult for states to justify involuntary sterilization. But I do think there's another lesson that's also worth remembering here. And that is that we talk sometimes about Supreme Court decisions as though they represent the final word on constitutional meaning. But in reality, history shows us something different. We have a Supreme Court that is made up of human beings. Human beings bring with them, assumptions and their prejudices and cultural beliefs of their own times. And most of the justices who decided Buck versus Bell believed that they were acting in the best interest of society. Today, we of course recognize that decision as a very profound violation of individual dignity. Okay? But studying constitutional law, it requires humility because it reminds us that even our highest court is capable of making very serious mistakes. It reminds us of why constitutional interpretation is never truly finished. Every generation inherits the responsibility of asking whether previous decisions faithfully protected the liberties that the Constitution was designed to preserve. And that's just the bottom line. And as we move into our next case, you're going to notice a very significant shift because until now, the Supreme Court has recognized parental authority, educational choice, and even procreation as important constitutional liberties. But the next question is going to be even more challenging. If the Constitution protects the decision to have children, does it also protect the decision not to have children? And that question would eventually lead the court to recognize a constitutional right that, although it's never mentioned by name in the Constitution, has shaped nearly every major substantive due process decision that followed. And that right is privacy. So by the time the Supreme Court reached Griswold versus Connecticut in 1965, the justices had already recognized several important liberties under the 14th Amendment. Parents had the authority to direct the education of their children. Families had the freedom to choose private schools. The courts had acknowledged that procreation was one of the most basic civil rights of humanity. And if you look back at those decisions together, you can almost see the court slowly moving toward a more broad principle, even if it hadn't yet given that principle a name. It would become privacy, though. So to understand why Griswold became such a landmark case, we need to understand the world in which it arose. Today, contraception is widely available, and for many Americans, it's viewed as ordinary parts of healthcare. All right, so it's difficult for modern students to imagine that there was a time that when even discussing birth control could expose someone to criminal prosecution. The roots of those laws stretch back to the late 19th century, when you have laws passed in 1873. It was the Comstock Act, and it was named after Anthony Comstock, and he was a social reformer who believed that contraception, sexually explicit materials, and information about reproductive health were morally corrupting influences. Okay, so the federal law prohibited the mailing of contraceptive devices and information about birth control through the United States Postal Service. So many states adopted similar laws, and they often called them the Little Comstock laws, all right, which imposed their own restrictions on contraception. Now, Connecticut had one of the strictest laws in the nation, and it made it a crime not only to sell or distribute contraceptives, but even for married couples to use them. So think about that for a moment. A husband and wife acting together, making a private decision about whether and when to have children, could be prosecuted by the state simply because they chose to use contraception. All right. So that reality seems a little extraordinary today, right? But it did reflect the social attitudes of the time. And many lawmakers believed that the government had the authority to regulate morality and that restricting contraception would encourage what they considered proper family values. Now, others saw it very differently. Enter Estelle Griswold. Okay, she was the executive director of the Planned Parenthood League of Connecticut. And Griswold believed that the law was unconstitutional, but she understood that the only way to challenge it was to intentionally violate it. All right, so together with it's Dr. I think it's C, the initial C, Lee Buxton. That was a physician and a professor at Yale Medical School. She opened a birth control clinic in New Haven, and they counseled married couples and they provided contraceptive devices, fully expecting that they were going to be arrested. And they were. All right. And their convictions eventually reached the United States Supreme Court, presenting the justices with a constitutional question unlike anything they had faced. Did the Constitution protect the right of married couples to make private decisions about contraception without government interference? Now, one of the reasons that Griswold remains one of the most fascinating constitutional cases that you'll ever study is that the court was attempting to protect a right that the Constitution never explicitly mentions. All right. So, Justice William Douglas wrote the majority opinion, and he immediately acknowledged the obvious problem. If you search the Constitution from beginning to end, you would never find the word privacy. There is no privacy clause. There's no amendment saying that citizens possess a constitutional right to make personal family decisions free from government intrusion. So how would the court protect a right that wasn't written down? All right. So Douglas answered that question by looking at the Constitution as a whole rather than focusing on a single amendment. Okay. And he argued that several provisions of the Bill of Rights created broader constitutional principles when read together. And he referred to these broader protections as penumbras, all right, formed by emanations from the specific guarantees contained in the Constitution. And those are unusual words, I know. So let's kind of slow down and unpack those. So a penumbra is the partially shaded area surrounding a shadow. All right, so imagine standing outside like on a bright afternoon, and a tree casts a dark shadow on the ground. But surrounding that dark shadow is a softer area where some light still reaches. That's the penumbra. All right, and Douglas actually used that image as a metaphor, and he argued that constitutional rights cast protective shadows beyond their exact wording. All right, freedom of speech, freedom of religion, protection against unreasonable searches and seizures, the privilege against self-incrimination, and the reservation of unenumerated rights, they all suggested that the Constitution protects this sphere of personal life into which the government should generally not be trying to intrude. All right, so in other words, although the Constitution never expressly says, it never explicitly says, rather, or expressly, you have a right to privacy, it guarantees through various combinations together to create what Douglas referred to as a zone of privacy. And marriage, he concluded, lies at the center of that protected zone. So the court described marriage as an intimate relationship that was deserving of constitutional respect. So decisions about whether or not a married couple should have children were viewed as profoundly personal and beyond the proper reach of the government regulation. And as a result, the Connecticut law was declared unconstitutional. So although Griswold specifically involved married couples, its significance extended far beyond contraception. So for the first time, the Supreme Court openly recognized that privacy itself could receive constitutional protection. And that recognition would then become the foundation for nearly every substantive due process case that follows. And I know I just touched on this a little bit, but I want to kind of go into it a little bit more because whenever I teach Griswold, there's one concept that does consistently cause students to pause, and understandably so, and it is the idea of the penumbras and the unenumerated rights. Those terms sound very abstract, but once you understand them, they become much more intuitive. Let's start with the phrase, the unenumerated rights. The word enumerated simply means listed or specifically identified. So for example, if I ask you to enumerate the first 10 amendments, you would list them one by one. So the Constitution it contains many enumerated rights. Freedom of speech, specifically listed. Freedom of religion, specifically listed. The right to bear and keep arms, again, specifically listed. Protection against the unreasonable searches and seizures, specifically listed. But does that mean that those are the only rights that Americans possess? And the framers, I think, anticipated that question because if you look at the Ninth Amendment tells us that the enumeration of certain rights in the Constitution should not be interpreted to deny or to disparage others retained by the people. So in other words, the framers understood that they could not possibly write down every liberty that citizens would possess. Imagine trying to complete a list of every important human freedom. It would be impossible. All right. Every generation faces new circumstances that earlier generations could have never anticipated. And Justice Douglas relied in part on that understanding. And he argued that constitutional protections should not be viewed as isolated islands. Instead, they work together to create broader principles that safeguard personal liberty. So think of the Constitution as a house. Each amendment represents a room with its own purpose. The First Amendment protects expression. The Fourth protects security within the home. The Fifth protects against, compelling someone with self-incrimination, right? And the Ninth reminds us that not every right has to be listed. And when you step back and you look at the entire house instead of one room at a time, you have a larger picture that begins to emerge. And that is the house itself protects a private sphere of life. And that was the idea that Douglas was trying to communicate. Now, I should tell you, not every justice agreed with this reasoning. And critics argue that Douglas was inventing constitutional rights rather than interpreting them. They believed that they should protect only those rights that were clearly grounded in constitutional text or, deeply rooted in history. And supporters responded that the Constitution was intentionally written in broad language precisely because its principles had to endure across generations. And that debate has never disappeared. Okay, it continues to today. Every single modern discussion about substantive due process eventually returns to the same question. Can judges recognize constitutional rights that are not expressly written into the Constitution, or should that task be exclusively to the people and their elected representatives? And that question becomes even more significant as we move into our next case, where the court has to decide whether privacy belongs only to married couples or whether it belongs to the individuals themselves. Now, I want you to imagine that you're sitting in the audience at the Supreme Court the day that Griswold versus Connecticut is decided. You've listened to the attorneys argue. You've heard the justices ask the questions. Then the opinion is announced, and at first glance, it sounds like it is a massive, victory for individual liberty. Connecticut can no longer make criminals out of married couples simply because they decide to use contraception. Okay? Government, the court says, they don't belong in that decision. And you walk out of the courtroom thinking, well, that settles that. But does it? Because imagine that you're walking down the courthouse steps with another attorney, and you turn to each other and you start talking about the opinion, and one of you finally says, wait, something about this doesn't quite sit right with me. And the other is like, well, what do you mean? And you go back to, well, the court keeps talking about marriage. Everything's about marriage. Privacy belongs to married couples. Marriage creates this protected relationship. But what if someone isn't married? And that's when you stumble into the next constitutional problem. So suppose you have two women who walk into the same doctor's office on the same afternoon. Maybe they're both the same age, 25, 26. Both have careers, both healthy. They both tell their physicians they are not ready to have children yet. And the doctor believes that contraception is medically appropriate for both of them. One woman is married, one woman isn't. Should the Constitution protect the one woman but not the other? And listen, don't answer that too quickly. Instead, ask yourself why. Why should a marriage license determine whether the government gets to make one of the most personal decisions of someone's life? Okay? And if you think it's an odd question, you're not alone. But a lot of lawyers thought it was an odd question too in the early 1970s. And there was a lot that was going on in the 70s. But the case forced the Supreme Court to answer it. It didn't begin with a married couple. All right, it began with a man named William Baird. And Baird spent much of his time traveling around the country speaking about family planning and reproductive health. And during one lecture that he was giving at a university, he finished answering questions. He reached into his bag and he handed out a package of contraceptive foam to an unmarried woman who had attended the presentation. That single act resulted in him getting arrested. Okay. And I always smile a little when I get to this part because students usually look at me like I've made a mistake. Like, what? He got arrested for that? He did. He wasn't arrested because he had injured someone. He wasn't arrested because he committed fraud or because he had assaulted somebody. He handed an adult woman a contraceptive product, and under Massachusetts law, that was enough. Okay. Sometimes constitutional law reminds us just how different the country looked only a few decades ago. So when I teach this case in person, I usually ask students to forget everything that they already believe about contraception because that's not actually the constitutional issue. Whether you personally support birth control or don't, right? It doesn't answer the legal question before the court. The legal question is so much more simple. Can the government treat two competent adults differently simply because one is married and one isn't? That's it. That's the entire case. Everything else is background. All right. The Supreme Court eventually answered the question with a sentence that completely changed the direction of substantive due process. Justice William Brennan wrote, if the right of privacy means anything, it is the right of the individual, married or single, to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. All right, and I want to stay with that sentence for a minute because I think students sometimes hear it, they write it down, they memorize it for an exam, and they move on without appreciating fully what happened. Like, remember how we described Griswold just a few minutes ago. The court kept talking about marriage. Marriage created the protected relationship. Marriage created the privacy interest. But listen to Brennan's language now. He doesn't begin with marriage. He begins with the individual, and that wasn't accidental. All right. The court had quietly shifted the entire constitutional conversation. The right didn't belong to the marriage anymore, it belonged to the person. All right. And I think that's worth stopping on because it's so much of a it's a bigger philosophical change than it first appears to be. Ask yourself the question, does the Constitution protect institutions or does it protect people? If your answer is people, then Brennan's opinion starts to make a lot of sense. Marriage didn't magically create privacy. Marriage simply happened to be the setting where the court first recognized it. Once the court acknowledged that privacy exists, it became much harder to explain, well, why unmarried adults should somehow possess fewer constitutional liberties than somebody who's married for making the same exact decision. Okay. Now, whether you agree with Brennan or not, it's almost beside the point. But as a future legal professional, what matters is understanding his reasoning. He's asking the court to stop focusing on the relationship and start focusing on the individual human that is standing before the government. And that's a very different way of thinking about liberty. So as I read these cases, I can't help but notice something different. Like every decision that we've studied has made the circle of liberty just a little bit larger, right? Meyer protects parents during their children's education. Pierce protected families when it came to choosing private schools. Skinner recognized that deciding whether to have children is one of the most basic civil rights that we possess. And now Griswold is protecting privacy within marriage. Now we have Eisenstadt. And it asks a very simple but profound question. And that is, if liberty belongs to all of us, why should it depend on whether or not we've said I do? And that's a very powerful question. The Supreme Court thought it knew the answer in 1972, but 14 years later, it's going to face an even harder question. And that is, does the same liberty protect two consenting adults of the same sex inside of their own home? And this time the court would answer no. And that decision would become one of the most scrutinized, actually, and criticized opinions in modern constitutional law. Now, if you've been following the progression of these cases, you have probably started noticing a pattern. And with each decision, again, the Supreme Court is broadening its understanding of liberty. It's protecting the authority of parents to direct their children's education. It's protecting the right to choose private education. Procreation is one of the most basic civil rights of humanity. And it's recognized a constitutional right to privacy within marriage and then expanded it to protect the individual beyond marriage. And I keep harping on these things because I want to drive home exactly how this progression is building. Looking at those cases together, it would have been reasonable to predict that the court would continue kind of moving in the same direction. History, though, has a way of reminding us that constitutional law is rarely a straight line. Okay? So the next case that we study is one that surprises students because it seems to kind of interrupt everything that we've been building toward. So instead of expanding liberty, the Supreme Court stops. And in fact, a lot of people would argue that it takes a very significant step backwards. All right, so whether you ultimately agree with the assessment or not, it's important to understand why the court reached the conclusion that it did, because 17 years later, the justices would revisit this very same question and openly acknowledge that they had changed their minds. Okay, and this story begins in Atlanta. Okay, I don't know if you know this or not. It actually happened 1986, so this one was during my lifetime. But Michael Hardwick, he had received a citation for drinking in public, relatively minor offense. But when he failed to appear in court because of a clerical misunderstanding, an arrest warrant was issued. So several weeks later, a police officer went to Hardwick's apartment to serve the warrant. A roommate answered the door and allowed the officer inside, believing that Hardwick was home. The officer searched the apartment and eventually entered Hardwick's bedroom. Okay? There, the officer observed Hardwick engaged in a consensual, intimate conduct with another adult man. Okay? Now, it's important to understand exactly what was and was not happening here. The police were not responding like to a complaint from a victim. There was no alleged violence. There was no accusation or coercion or assault. Um, the conduct occurred inside a private residence between two adults who had both consented. All right. Nonetheless, Georgia law at the time made certain intimate acts criminal offenses, and he was arrested under the statute. Now, as lawyers, one of the first things, or as not necessarily lawyers, but legal professionals in general, one of the things that we should first ask ourselves is how we frame the constitutional question. This is something that you'll find yourself doing through your legal careers because the way a legal question is framed often influences the answer. So if I ask whether the Constitution protects a person's liberty to make private decisions inside of their own home, that sounds like one question. But if I ask whether the Constitution protects a specific sexual act that has historically been prohibited by state law, that sounds like a different question, even though both are arising from the same facts. Okay? So the Supreme Court recognized that it wasn't simply deciding Michael Hardwick's case. It was deciding how broadly or narrowly it would define liberty itself. So when the court issued its decision, the majority ruled against Hardwick. Justice Byron White wrote that the Constitution did not recognize a fundamental right protecting the conduct at issue. And he observed that the laws prohibiting same-sex intimacy had existed for centuries and argued that rights receiving substantive due process protection should generally be those deeply rooted in the nation's history and traditions. So because the conduct challenged in Bowers had been historically criminalized, the majority concluded that it didn't qualify as a fundamental liberty protected by the 14th Amendment. Okay? So whether you agree with the conclusion or not, I want you to just take note of the methodology. The majority wasn't simply saying, we don't like this conduct. Instead, it was asking a historical question. Is this the type of liberty that Americans have traditionally recognized as fundamental? So for Justice White, history provided that answer. And that approach reflects a philosophy of constitutional interpretation that you'll encounter repeatedly throughout this course. You have some judges who believe that when courts identify unenumerated rights, rights again that are not expressly listed in the Constitution, that they should proceed very cautiously. Otherwise, judges could risk substituting their own personal values for constitutional law. And in their view, if society wishes to recognize new rights, that responsibility generally belongs to the legislatures or to the people through the amendment process rather than to the judiciary itself. Okay? Now, other justices see the Constitution differently, and they believe that broad constitutional principles, such as liberty, necessarily requires interpretation as society is changing. All right, so they argue that history is important, but it should not be the only consideration because history has often excluded, groups that later generations recognized deserved equal constitutional protection. So neither philosophy is inherently irrational. Both begin with a desire to remain faithful to the Constitution. They simply disagree about how that faithfulness should be measured. And those competing approaches were on full display in Bowers, okay? And nowhere was that disagreement more evident than in the dissent. Now, one of the habits that I hope that you develop as you continue studying constitutional law is reading the dissents and read them with as much care as you read the majority opinions. A dissent does not establish the law, but sometimes it plants ideas that later become the law. And constitutional history is filled with dissents that eventually became majority opinions years or decades later. Now, Justice Harry Blackmun wrote one of the principal dissents in Bowers, and he believed the majority had the wrong constitutional question from the beginning. So rather than asking whether the Constitution protects a particular sexual act, Blackmun argued that the court should have asked whether adults possess the liberty to make private consensual decisions about their intimate relationships without government interference. And that difference may seem subtle, but constitutionally, it's huge. Okay? So imagine someone asked whether the First Amendment protects flag burning. Another person might respond that the real question isn't about flags at all. The real question is whether the government can punish expressive conduct simply because it disagrees with the message being conveyed. Two totally different ways of framing the same dispute, but they produce different answers. So Blackmun believed that Bowers should have been viewed through a more broad lens of personal autonomy rather than through the narrow lens of a specific criminal statute. Now, in one of the most memorable passages of his opinion, he wrote that the case concerned, quote, the right to be let alone. Okay, a phrase that now echoes through decades of privacy jurisprudence. Okay, as I read this case, I'm always reminded of something that we've talked about throughout the semester, and that the Supreme Court, I do believe, is made up of some somewhat brilliant minds, but those justices don't always disagree because one side understands the Constitution and the other does not. More often, they disagree because they begin from different assumptions about constitutional interpretation. The majority believed history should largely determine whether an unenumerated right exists. The dissent believed history should inform the analysis, but not necessarily control it. So for the next 17 years, Bowers versus Hardwick remained the law of the land. Okay? States retained the authority to criminalize consensual, intimate relationships between adults of the same sex. So during those same 17 years, American society continued to change. Public attitudes shifted. Conversations about equality became more common. Courts began reconsidering how they understood liberty, privacy, and dignity. And eventually, another case reached the Supreme Court involving very remarkably similar facts. Okay? This time, though, the court looked at the Constitution through a very different lens. All right? And that decision that followed, it did something that the Supreme Court does only rarely. It didn't distinguish an earlier case. It didn't quietly limit its application. It very explicitly declared the court was wrong. And that case was Lawrence v. Texas. And it became one of the most significant substantive due process decisions in modern constitutional law. So, one of the things that I appreciate most about constitutional law is that it reminds us the Supreme Court is not infallible. Again, we sometimes talk about the court as though every opinion it issues is, the final and maybe even perfect interpretation of the Constitution. But again, history still tells us that different story. And the court has overruled itself hundreds of times. And sometimes that happens because society changes. Sometimes it's because new justices bring different philosophies to the bench. And occasionally, however, it's because the court simply concludes that it just got it wrong the first time. And that is what happened in Lawrence v. Texas. Now, the facts of the case are very similar to Bowers versus Hardwick, which is one of the reasons that the cases are almost always taught together. So in 1998, police officers in Harris County, Texas, received a report that an armed man was causing a disturbance inside of an apartment. Believing that they were responding to a potentially dangerous situation, officers entered the apartment of John Lawrence. Now, the emergency report turned out to be false. There was no violent crime taking place. There was no hostage situation. There wasn't even a weapon involved. Instead, the officers encountered John Lawrence and Tyrone Garner. They were two adult men engaged in consensual, intimate conduct inside of Lawrence's home. Now, once again, nobody had been injured. No one had called the police to complain about the relationship itself. The officers happened to observe conduct that violated a Texas criminal statute, and both men were arrested. And if that sounds familiar, it should. we look at these facts and think, we've seen this movie before, because 17 years earlier, the Supreme Court upheld a very similar law in Bowers versus Hardwick. So if precedent means anything, and generally it means a very great deal, then you might expect the court to reach the same, conclusion again. But precedent has never meant an earlier decision is untouchable. So one of the most important principles that we've discussed throughout, this semester is stare decisis. And that is the idea that courts should generally follow prior decisions in order to promote consistency and stability in the law. Now, the word generally, however, does a lot of work in that sentence. All right. Stare decisis is an important principle, but it's not an absolute command. So if the Supreme Court becomes convinced that one of its earlier decisions is fundamentally has misunderstood the Constitution, it has the authority to revisit that decision, and that's what happened here. So Justice Anthony Kennedy wrote the majority opinion, and before he ever discussed the Texas statute, he reframed the constitutional question. So remember how we talked about the importance of framing, right? The majority in Bowers had asked whether there was a fundamental right to engage in homosexual sodomy. Kennedy believed that was the wrong question. He argued that the case wasn't really about a particular sex act at all. Instead, it concerned whether adults possess the liberty to make private, consensual decisions about intimate relationships without government interference. So, do you hear how different those two questions are? One focuses on conduct, the other focuses on liberty, and that shift in framing changed everything. So, Kennedy explained that the Constitution protects more than freedom from physical restraint. All right. Liberty, he said, includes the ability of individuals to make certain personal decisions concerning their relationships, their identities, and their private lives. The government cannot simply enter in the home and criminalize private conduct between consenting adults because a majority happens to disapprove of it morally. Now, one sentence from Kennedy's opinion became particularly well known, and he wrote that the petitioners are, quote, entitled to respect for their private lives. And that is a remarkably simple sentence, but it has such constitutional weight. Notice that he didn't say that the government had to approve of the relationship. He didn't say that everyone had to agree with it. He said that the Constitution requires the government to respect the private liberty of individuals in circumstances where no one is being harmed. And then came the sentence that transformed the constitutional law. Justice Kennedy wrote that Bowers versus Hardwick was, quote, was not correct when it was decided, and it is not correct today. All right. And that's about as direct as the Supreme Court could ever get. All right. The court didn't distinguish Bowers. It didn't limit Bowers. It didn't quietly ignore Bowers. It overruled it. And we should appreciate how unusual that is, because courts are generally reluctant to overrule precedent because stability matters. Businesses rely on precedent. Individuals rely on precedent. Lower courts rely on precedent. So every time the Supreme Court changes course, it creates uncertainty. And that's one reason that the courts usually prefer to distinguish earlier cases rather than just abandon them entirely. So in Lawrence, the majority concluded that the constitutional cost of leaving Bowers in place was greater than the institutional cost of overruling it. And in Kennedy's view, Bowers had misunderstood the nature of liberty that was protected by the 14th Amendment, and correcting that mistake was more important than preserving an earlier precedent. Now, as con law students, it is easy to focus on the holdings of cases and lose sight of the larger themes that connect them. So I want to pause for a minute because Lawrence represents something bigger than simply just invalidating, one Texas statute. It reflects a significant shift in how the Supreme Court talked about liberty itself. So if we go all the way back to Meyer, the court focused primarily on parents directing the education of their children. So in Pierce, again, it emphasized, parental authority and educational choice. Skinner recognized the importance of procreation. Griswold introduced constitutional privacy within marriage. And then Eisenstadt, it expanded that privacy to the individual. Okay? Now, throughout those decisions, one word appeared repeatedly: privacy. So when Justice Kennedy wrote Lawrence, another word began taking center stage, and that was dignity. And that wasn't accidental. Privacy asks whether the government should stay out of certain aspects of our lives. Dignity asks whether the government should treat every person as possessing equal worth and respect under the law. And those concepts overlap, but they're not identical. Okay? So imagine that a government, it promises to never enter your home without permission, but also passes a law declaring your most intimate relationships to be criminal simply because a majority disapproves of them. Technically, you might still have privacy in some sense, but would you have dignity? All right, would the law be treating you as an equal citizen? So Kennedy believed the Constitution protects both. All right, that's one reason that Lawrence is often described as a case about human dignity as much as it is about privacy. The opinion repeatedly emphasizes respect, autonomy, and the freedom to define one's own personal relationships without unnecessary governmental interference. So whether someone agrees with Kennedy's reasoning or not, it's impossible to deny that he changed the vocabulary of substantive due process. The conversation was no longer limited to privacy alone. It now included concepts like dignity, autonomy, and identity. Okay? It's also worth remembering that constitutional decisions rarely exist in isolation. So once Lawrence recognized that consenting adults possess liberty interest in their intimate relationships, another question naturally followed. So if two adults have the constitutional liberty to build a life together, what happens when they ask the state to recognize that relationship through marriage? That question would then bring the Supreme Court face to face with one of the most significant constitutional controversies of the 21st century, and that was the case of Obergefell versus Hodges. This was not simply about marriage licenses, it was about whether the Constitution permits states to exclude an entire class of individuals from one of the oldest and most significant legal institutions in American society. And as you will see, the answer the court gave relied heavily on nearly every case that we have studied throughout this lecture. So when students hear the name Obergefell versus Hodges, they almost immediately associate it with same-sex marriage. And that certainly was the case that it was known for, but I would encourage you to think about it in a more broad constitutional sense. This case was really the culmination of nearly a century of substantive due process jurisprudence. Every case that we've talked so far, from Meyer to Pierce, from Skinner to Griswold, from Eisenstadt to Lawrence, we have been building towards one central question: that if the Constitution protects deeply personal, decisions about family, relationships, and autonomy, does that protection extend to the decision to marry the person that you love? And to answer that question, we have to remember something that often gets lost in public discussions of this case. The Supreme Court did not invent the idea that the marriage is a fundamental right in 2015. It had been saying exactly that for decades, okay? Go back to Loving versus Virginia. That's a case where you have, it's an equal protection case. Richard and Mildred Loving, an interracial couple whose marriage violated Virginia law. Supreme Court unanimously struck down those laws, explaining that marriage is a fundamental right of free people. Years later, you have Zablocki versus Red Hale. The court invalidated a Wisconsin law that prevented certain individuals with unpaid child support obligations from marrying without judicial approval. Again, court emphasizing that marriage occupies this unique place in our constitutional tradition. So by the time Obergefell reached the Supreme Court, the constitutional debate wasn't really whether marriage was fundamental. That question had been answered. The question was whether the states could limit that fundamental right to opposite sex couples only, rather. So the facts of the case are both legally significant and very deeply human. So you have James Obergefell, who had been in a committed relationship with John Arthur for more than 20 years. In 2011, Arthur was diagnosed with, it was ALS, Lou Gehrig's disease. And as his condition got worse, and the couple decided they wanted to get married before Arthur died. But there was a problem. The state didn't recognize same-sex marriage. So because Arthur's illness made travel very difficult, the couple chartered a medically equipped airplane, flew to Maryland where same-sex marriage was legal. The ceremony took place on the airport, tarmac, because Arthur was just too ill to go any further. They exchanged vows, they returned home, and they hoped to spend out their remaining time together as a legally recognized married couple. But Ohio refused to recognize their marriage. All right. That refusal had consequences that extended far beyond any kind of symbolism, because when Arthur died, Ohio then intended to list him as unmarried on his death certificate, because under state law, the marriage simply did not exist. Okay. I want you to think about that for a moment. All right. Imagine spending more than 20 years building a life with somebody. Imagine caring for that person through a terminal illness, and imagine marrying them in another state because your own state won't allow it. And then imagine being told after they die that your relationship will not even be acknowledged on the official record documenting their death. Whether you agree with same-sex marriage or not, it's difficult to ignore the very profoundly personal nature of that dispute. And that's exactly what made this case so significant. The Supreme Court wasn't deciding an abstract political question. It was deciding whether the Constitution protected one of the most important relationships that a person can form. Now, Justice Anthony Kennedy once again wrote the majority opinion. And if you've been paying attention throughout today's lecture, then you notice many of those themes that we've discussed appearing together in a single decision. But Kennedy didn't rely on one case. He relied on decades of constitutional development. He began by acknowledging something that had already become familiar in substantive due process cases. The Constitution protects certain personal choices because they are central to individual liberty. Marriage, he said, is one of those choices. Okay? So Kennedy identified several reasons why marriage occupies a unique constitutional position. And he explained that marriage supports individual autonomy because choosing whom to marry is among the most intimate decisions that a person can make. And he noted that marriage represents a profound commitment between two people and provides legal stability for families. He also emphasized that marriage protects children by providing legal recognition and security to the family unit. And then he finally observed that the marriage has been one of foundational institutions of American society, period. Okay? Notice that none of those reasons depend on whether or not the person involved in the relationship is involved in an opposite sex or a same-sex relationship. All right? That observation became central to the court's reasoning. So Kennedy concluded that excluding same-sex couples from civil marriages denied them both liberty under the Due Process Clause and equal protection under the 14th Amendment. Those two constitutional principles, he explained, often reinforce one another. So liberty protects the individual's ability to make fundamental personal choices, and equal protection ensures that the government does not arbitrarily deny those choices to one group of citizens while allowing another group to exercise them. Now, the most quoted passage from the opinion kind of captures this beautifully. Kennedy wrote that same-sex couples seek, quote, equal dignity in the eyes of the law. Okay? Notice the phrase equal dignity. That is the same concept that we discussed in Lawrence. Privacy had gradually evolved into a broader constitutional conversation about dignity, autonomy, and equal citizenship. So the court therefore held that the states cannot prohibit same-sex couples from marrying, and they have to recognize same-sex marriages lawfully performed in other states. All right, and as with every controversial constitutional decision, this opinion generated both celebration and criticism. All right, supporters viewed it as the logical conclusion of decades of substantive due process jurisprudence. Critics argued that the court had removed an issue from democratic debate and recognized a constitutional right that was not expressly found in the text of the Constitution. All right. And those criticisms are important because they bring us to one of the enduring debates in constitutional law. And that is, how should judges decide cases involving rights that are not specifically listed in the Constitution? And that debate existed long before Obergefell, and it continues today. So, as we begin wrapping up today's discussion, again, I want to leave you with something that I think is more valuable than simply memorizing case names and holdings. And that is that constitutional law is not just about knowing what Supreme Court, has said. It's about understanding why reasonable people can read the same Constitution and reach very different conclusions. And if you've listened carefully throughout this lecture, you've probably noticed two competing philosophies kind of appearing again and again. One philosophy asks, what did the Constitution originally mean when it was adopted? So judges who generally begin with that question are often described as originalist. And originalism does not necessarily mean ignoring modern society. Rather, it reflects the belief that the constitutional interpretation should remain closely tied to the original public meaning of the text. So if a claimed right was not understood to exist when the relevant constitutional provision was adopted, originalists are generally reluctant to recognize it through judicial decision making. And they often argue that social change should occur through legislatures and constitutional amendments rather than through the courts themselves. Now, the other philosophy asks a different question, and that is, rather than focusing on historical understandings exclusively, these judges ask, how enduring constitutional principles apply to circumstances the framers could have never anticipated. And that approach is often described as the living Constitution. And the idea is not that the Constitution itself changes, but that its broad principles, such as like liberty and equality, must be interpreted in light of new situations, new technologies, new social developments, okay? So neither philosophy is inherently simplistic and neither is limited to one political party. Both are grounded in efforts to remain faithful to the Constitution. They simply disagree about the role that judges should play when interpreting broad constitutional language. And you'll hear these debates whenever the Supreme Court considers questions involving privacy, marriage, reproductive rights, medical decision making, digital privacy, and even emerging technologies. And in many ways, the real disagreement isn't over the work or isn't over like the specific issue that's before the court, right? It's over how the constitutional interpretation itself should work. So as future paralegals, lawyers, whatever you go to be, your responsibility isn't to decide which philosophy is correct, before understanding both of them. Your responsibility is to recognize the legal reasoning each side brings to the discussion. The best legal professionals can explain arguments they personally disagree with because they understand those arguments fairly and accurately. And that's one of the habits that I hope you develop throughout this course. Don't stop at asking who won the case. Ask why. Ask what constitutional principles the court relied upon. Ask what the dissent feared might happen. Ask whether the reasoning fits consistently with earlier decisions. Those questions will make you a stronger legal thinker than just simply memorizing an outcome, okay? And perhaps most importantly, remember that constitutional law is never static. Every generation inherits the Constitution, but every generation also inherits the responsibility of interpreting it. And the conversation that you've seen unfold over the last century, it's not over. In many respects, it's just beginning, okay? I completely cut the other slide off before I finished giving you what I wanted to say. So I'm just going to combine these two kind of together. But now that we've worked our way through, nearly a century of Supreme Court decisions, I do want you to step back, from the individual cases and look at this bigger picture. One of the easiest mistakes that students make in constitutional law is, again, treating it like it's an isolated event. You memorize the facts, you identify the issue, you learn the holding, and you move on to the next case. If you study that way, you're going to miss the story that the Supreme Court has been telling for hundreds of years. Just simply look at the progression that we follow today. We began with education, Meyer and Pierce. They weren't really about German language instruction in private schools, they were about parents. The Supreme Court recognized that there are certain decisions that the government cannot simply take away from families because government officials think they know better. Okay? Those cases established that liberty includes more than freedom from imprisonment. It includes the authority to direct the upbringing of your children. All right, from there, the court moved into an even more personal area with, Skinner, where they forced the justices to confront a government claiming the authority to decide who should be allowed to have children. And once again, the court recognized that there are constitutional limits to this governmental power. The ability to create this family, the court explained, is one of the most basic civil rights that we possess. And that naturally led to another question, that if the government cannot decide whether you have children, can it decide whether you use contraception? Well, Griswold answered that question by recognizing the constitutional right to privacy within marriage. Eisenstadt expanded it by explaining that privacy belongs to individuals also, rather than to just married couples. So the court then encountered, one of the most difficult decisions in modern constitutional law, and that is, does liberty protect private relationships between consenting adults? In Bowers, the court said no. 17 years later, they said yes. They said that case misunderstood the meaning of liberty, and then Obergefell asked whether or not the fundamental right to marry could even be denied to same-sex couples, bringing together many of the constitutional principles that were developed over the previous century. So if you have to summarize, this progression in a single sentence, I think it would be this, and it's that the Supreme Court gradually shifted its understanding of liberty from protecting specific activities to protecting personal autonomy. And that's an important distinction. Early cases focused on education, later cases focused on families. Court then began talking about privacy, and eventually it began talking about dignity and autonomy. And if you look at it, the vocabulary itself evolved as well. Okay, so as society changed, so did the court's understanding. Of what it meant for individuals to live freely within a constitutional democracy. So whether you agree with every single one of those decisions is kind of a beside the point, for our purposes at least. What matters is recognizing how constitutional law, or constitutional doctrine rather, develops. The court rarely wakes up one morning and says, I think I'm going to do a new principle today. More often than not, each one of those decisions builds carefully upon those that came before it. So understanding those connections is what separates someone who has memorized the cases from someone who truly understands the constitutional law. No doctrine in constitutional law is without criticism, and substantive due process is definitely no exception. In fact, some scholars consider it one of the most controversial doctrines that the Supreme Court has ever developed. And the first criticism that you'll often hear is that substantive due process encourages judicial activism. That means that phrase, gets used frequently in political discussions, but it is worth understanding what it actually means. And generally speaking, a judge is described as engaging in judicial activism when critics believe the judge has substituted personal preferences for constitutional interpretation. Those critics argue that because rights like privacy are not explicitly mentioned in the Constitution, that judges have no legitimate authority to create them through judicial opinions. Now, their concern is rooted in separation of powers. In our constitutional system, legislatures write laws, executives enforce them, and courts interpret them. So if judges begin identifying new constitutional rights that are not expressly listed in the Constitution, critics worry that courts begin functioning more like legislatures than judges. All right. Now, supporters of substantive due process respond with an entirely different argument, and they point out that the Constitution itself uses broad language rather than attempting to list every conceivable liberty possible. All right. They also remind us of the Ninth Amendment, which specifically acknowledges that the people possess rights beyond those expressly enumerated. So, from that perspective, recognizing certain unenumerated rights is not judicial activism at all. It is simply taking constitutional liberties seriously. Another criticism involves predictability. So, if constitutional rights are not specifically listed, then how does the court even begin to determine which liberties qualify as fundamental? Why protect one right but not another? Those questions continue generating disagreement among judges, scholars, attorneys, again, because there's no mathematical formula for identifying fundamental rights. So, as you continue studying constitutional law, I encourage you not to dismiss either side of this debate too quickly. The best legal professionals, again, are going to understand those opposing arguments before deciding where they stand. So whether you ultimately agree with substantive due process or believe that the doctrine extends judicial authority too far, you'll be a stronger legal thinker if you can fairly explain both positions. We're almost done, I promise. At this point, you might be wondering even why any of this matters outside of a constitutional law classroom. Um, and in all reality, very few paralegals are going to spend their careers, briefing Supreme Court cases. But the answer is that constitutional principles shape almost every area of legal practice. They shape our lives. So if you work in family law, questions about parental rights and educational decisions, adoption, reproductive issues, they all may involve constitutional principles that we've talked about today. If you work in healthcare, you'll encounter questions involving informed consent, medical autonomy, end of life decisions, patient privacy, governmental regulation for healthcare providers. And many of those trace their constitutional foundations directly back to substantive due process. You have employment law. It increasingly raises questions involving personal privacy, employer monitoring of electronic communications, biometric information, workplace autonomy, things like that. So, as technology evolves, courts continue asking where legitimate business interest in and individual privacy begins. Technology law. This has become one of the fastest growing areas that's been influenced by substantive due process. And every day you have companies that collect extraordinary amounts of personal information about us. Our phones, they know where we've been. It watches our monitor for our heart rates, and, our vehicles record our driving habits, and, artificial intelligence systems, they can analyze our voices, our faces, and even predict aspects of our behavior. And as these technologies continue developing, the courts will inevitably confront new constitutional questions about privacy that previous generations never could have imagined. And that's one of the reasons that constitutional law never becomes outdated. The cases may be decades old, but the principles continue evolving because society keeps presenting new questions. All right, so the Constitution doesn't provide a direct answer for every modern problem. Instead, it provides principles that lawyers and judges must thoughtfully apply to circumstances that change from generation to generation. Now, as we finish out today, I'd like to leave you with a question rather than an answer. And throughout this course, we have kind of repeatedly returned to this idea of the Constitution limiting governmental power. Today's lecture, asks where those limits exist when the government attempts to regulate the most personal aspects of our lives. All right. The Supreme Court has answered that question differently at different points in history. And there is reason to believe that those conversations will continue long into the future. So here's the question I'd like for you to think about before completing your discussion for this week. And that is, should liberty evolve as society evolves, or should constitutional liberty remain limited to those rights historically recognized when the Constitution and the 14th Amendment, were adopted? And there isn't a simple answer. And that's precisely why constitutional law remains one of the most fascinating areas of legal study, in my opinion. You have intelligent people, they're acting in good faith, and they have disagreed about that question for generations. So your responsibility isn't simply to choose a side, it is to understand the constitutional reasoning supporting each decision. In our next module, we're going to get even deeper in this, following the development of substantive due process into one of the most controversial areas of constitutional law. And we're going to examine the constitutional evolution of abortion jurisprudence from Roe v. Wade through Planned Parenthood versus Casey, and ultimately Dobbs versus Jackson's Women's Health Organization. We're also going to discuss the constitutional right to refuse medical treatment, physician-assisted suicide, and the difficult legal and ethical questions surrounding the end of life. So as you prepare for that lecture, just remember something that we've discussed throughout today's class, and that is that constitutional law is rarely about isolated cases. It's about these controversies that create moments for conversations that will continue to unfold across generations. So every case that we've studied today, it's become a part of the foundation for the cases that we'll study next week. And that's what makes constitutional law so remarkable. The conversation will never really end. It simply is going to pass from one generation of lawyers, judges, and citizens to the next.